Any mention?
Please, Lordship, I beg to mention item number 4 of the supplementary list. It's a hearing matter, my lords. This matter was listed yesterday. I could not appear. I apologize, my lords. There was a settlement between the parties. Some talks of settlements that has not materialized. So we just wanted to inform this court. If it is okay, if it's convenient to the court's, matter can be taken up on Friday or next week for hearing.
No settlement is possible.
It's not happened so far.
Okay, we'll just say. And the request. You are for the?
I am for the respondent or for the petitioner.
It's a joint pair for.
Joint privilege.
Yes, sir. The joint pair, this matter after a week.
May I beg your lordship, I beg to mention item number 5 from the daily list.
Yes.
Your lordship, if this matter can come after 2 weeks. I've already informed the other side, your lordship.
Where are they? None.
They're not here, your lordship, but I had already informed them.
Item. So you have no objection, Mr. Siddiqui. Just say the request made on behalf of the respondent. This is matter after 2 weeks.
2 weeks, your lordship.
After 2 weeks.
I'll oblige, your lordship.
Your lordship, may I speak to item number 10?
Item number?
10.
Yes.
This regarding the POXO case, your lordship, and the matters below the age of 18 years, but more than 17 years was there, so pertaining to Muslim customary law.
Yes.
So in this matter, I am just searching, and then this honorable court seeing this matter, pertaining to this matter is pending the Supreme Court.
You want some time?
Sometime.
No objection, your lordship. Then on the request made on behalf of the petitioner, list after 2 weeks. Yes.
May I please, your lordship? I beg to mention item number 9, your lordship. I prefer 2 weeks' time, your lordship.
Why 2 weeks' time?
Due to personal difficulty of the conducting counsel, your lordship.
There are 4 counsels here. Who has personal difficulty? All 4 counsels. Yes, other side?
No objection, Lordship. You don't have.
9 also.
May I please, your lordship? Similar player for item number 11, your lordship.
Who is there? Other side? Item?
Statement. No objection.
Okay, item 11.
Highly obliged, lordship.
May I please, your lordship?
Yeah.
Lordship, I beg to mention item number 7.
You are appearing for?
The respondents. Okay. Praying for 2 weeks' time, your lordship.
I'm for petitioner, my lord.
No objection. 2 weeks on the request made by respondent.
I'll oblige.
Yes.
May I please, your lordship? Your lordship, I beg to mention item number 5, your lordship.
Why all the matters are mentioned? Just tell us. The mentioning has to be stopped, please.
What do you mention?
Item number 5. Already mentioned.
Supplementary cause list.
Wait, please, your
Item number
lordship.
1.
Your lordship, I beg to mention item number 11, your lordship, the daily cause
Has been
list.
mentioned. 11 is also mentioned.
Obliged, lordship.
Yes. Yes, Mr. Chairman.
Please, your lordship. So item number 1, 2, and 3 are connected matters. 482 applications where I'm seeking quashing of an FIR. There's a short facts of the case are, this is a property dispute where the allegation in the FIR made by the respondent number 5, who's the complainant, is that some of her family members has sold off an ancestral property, excluded her from the process, and have deprived her of the sale proceeds. That is the essential allegation in the FIR. And on the basis of this, these proceedings have been initiated and I have received notices under 41A for investigation. May I just take lordships to the short facts of the case. Now, this property relates to
Is
one
it FIR registered under what section?
415, cheating.
415.
415. 417, that's the punishment. The allegation is of cheating. So this property is located in Fruit Garden in Motinagar. This is owned by one Padmanath Borgoya. He died in 2019. During his lifetime, his family comprised of his wife, his daughter, who's the petitioner in item number 2, his wife is the petitioner in item number 1, and his son, who had predeceased him. His son was survived by his widow, who's the complainant and the respondent number 4 herein, and 2 children.
Deceased died, leaving behind his wife
And his daughter. His son had predeceased him.
and his daughter-in-law,
Daughter-in-law and 2 grandchildren.
grandchildren.
2 grandchildren. Now, after his death in 2019, the petitioner and her daughter got in touch with the respondent number 4, who's the daughter-in-law, and informed her that they were in talks to try and they were intending to sell the property in Motinagar, because they were not in a position to take care of that property because of their continued absence from Shillong. She agreed because during the lifetime, the son, that is Raktim Borgoya, who had predeceased Mr. Padmanath Borgoya, he had relinquished his share in the property. So the respondent number 4 did not raise any
How he
objection
relinquished any
by a family arrangement, oral family arrangement.
by executing any
No,
document?
there was no documentary evidence. There was a family arrangement between the parties. So eventually, the respondent number 4 did not raise any objection, as a result of which
It is a self-acquired property of
self-acquired property of Mr. Padmanath Borgoya. So ultimately, after his death and after the consultation with the respondent number 4, the property was mutated in the joint names of the petitioner in item number 1 and petitioner in item number 2. That is the mother and the daughter. Following that, they entered into negotiation with the purchaser.
the daughter-in-law did not give her no objection, nothing.
She did not give a no objection. This was not obtained.
How it was not obtained?
This was not obtained. She did not raise any objection as such because she was aware that her deceased husband had relinquished his share in the property. So following this, a mutation was obtained from the office of the Deputy Commissioner, and after that they entered into a negotiation with a private purchaser, and it was sold by a sale deed dated 12/4/2022. The entire property was sold off. Thereafter, the respondent number 4 issued a legal notice. Well, let's kindly have the legal notice. This is at page 43.
Yes.
Lordships have it. This is a legal notice dated 8/9/2022. So kindly see who it is addressed to. It is addressed to serial number 1 is Nilima Borgoya. She is the petitioner in item number 1. And Rinjim Borgoya, she is the petitioner in item number 2. So this reads, under the instruction of my client so-and-so, I hereby give you notices under that my client is the widow of late Raktim Borgoya, son of late Padmanath Borgoya, who are the legal heirs of late Padmanath Borgoya, who expired on 26/11/2019. That my client's father-in-law, late Padmanath Borgoya, had left behind a plot of landed property with a house standing thereon, situated at Fruit Gardens, Shillong, measuring an area of 910 square meters, more or less covered by plot number 44. That my client has learned from a very reliable source that the above noted landed property of her father-in-law has been sold illegally and applying fraudulent means without any kind of information whatsoever by both of you in the month of April 22 to one so-and-so who is the new lessee of the aforesaid property. That when my client inquired about the status of the aforesaid landed property, you have misguided her by saying that the property has been rented out, but actually you have illegally and applying fraudulent means sold the property behind the back of my client, and your acts amount to a case of breach of trust, cheating, forgery, as well as misappropriation of the share of sale proceeds of my client and her children. Under the above factual situation, you are therefore asked to transfer my client's share of the sale proceeds to my client immediately and unconditionally on or before 15 days from the receipt of this legal notice, failing which my client shall be compelled to file civil as well as criminal proceedings against both of you before the court of law for redressal of her genuine grievances. So, first point that is to be noted, that as on 8/9/22, she was aware that a sale had taken place. And at this point, she did not file any FIR. Kindly turn to the next page. At page 45 is another legal notice dated 7/11/22. Lordships have it?
Yes.
This reads, under the instruction of my client so-and-so, I hereby give you reminder notices under that my client has sent both of you legal notice dated 8/9/22 by speed post, and the same is delivered to you on 12/9/22. But even after receiving the legal notice, both of you have neither replied nor initiated any steps to sort out this issue amicably. Kindly also take note of that. Under the facts and circumstances, you are hereby requested to cooperate with my client and give her the share of the sale proceeds of the Shillong property, which you have sold without any intimation to my client. Under the above factual situation, my client have decided to offer you both a last chance to settle the issue amicably within the family within a period of 15 days and from the date of receipt of this reminder notice, in the best interest of justice and equity, failing which my client shall be compelled to file civil as well as criminal proceedings against both of you before the court of law for redressal of her genuine grievances. This is followed by yet another legal notice dated 23/2023.
You did not respond to all those legal notices.
Well, I'll just coming to that. They did not respond. In fact, they initiated verbal communication with the parties, and there was a talk of settlement which was initiated. This is evidence from this particular legal notice. If Lordships have it at page 47,
Yes.
this is a notice dated 23/2023. Now, this reads, I was expecting your call. Now, this is addressed to the counsel, the petitioner's counsel, to Mr. Rajesh Bora.
How he comes to picture?
My lord,
How Mr. Rajesh Bora came into picture?
this is the counsel of the parties. They had initiated, and my lords will find at page 50, copies of this were sent to the petitioners as well. Kindly see page 50. There were talks of settlement between the parties. The petitioners had engaged a counsel in Guwahati. He initiated the talks of settlement with the respondent number 4's counsel. So that is how the two counsels came in the picture. And they were initiating a dialogue on behalf of their clients.
So Rajesh Bora was your representative.
Lordship. In Guwahati. So this reads, I was expecting your call as you had called me and expressed willingness to discuss and settle the issue in hand. But I'm sorry to state that in spite of giving ample opportunities from the date of first legal notice dated 8/9/22 and followed by reminder legal notice dated 7/11/22 to settle the issue amicably, but your client is delaying it for reasons best known to you. I am sending my client's conditions for the mutual settlement of the issue and certainly believe that you will initiate the process without any further delay in the best interest of both the parties as you had offered earlier. Firstly, with regard to the Shillong property, which was actually given to my client's late husband, Roktim Borgoya, verbally by his father, late so-and-so, during his lifetime. But immediately after the demise of my client's father-in-law, late so-and-so on 26/11/2019, your client, Srimati Nilima Borgoya, along with your client's daughter and her husband so-and-so, behind the back of my client so-and-so, illegally transferred the property in their name, depriving my client from her legal share of the whole property, which is unfair, unethical, unlawful, against violation of principles of natural justice. Further, they have also sold the property behind the back of my client's knowledge, which has shocked my client and caused her mental tension and harassment. My client, late so-and-so, under compelling circumstances, had to serve legal notice to your client and her daughter, but they prefer to remain silent for all these years. Now, kindly take note of this. Finally, you have contacted me and expressed the desire to give my client a share of 1/3 of the total properties. Now, this is what she is legitimately entitled to under law, 1/3 share. Anyway, now my client wants her share of 50% of the actual sale proceed amount received by your client from the sale of the Shillong property within 10 days from receipt of this letter. This was a completely illegal and unjustified demand. Thereafter, secondly, that you had also promised her to pay her monthly rent from the month of April 22 over phone, but unfortunately you have totally failed to keep your commitment as given by you over phone to my client till date for reasons best known to you. So your client is hereby requested to clear the dues of rent with effect from April 22 till date onwards within 10 days and so on. Thirdly, my client so-and-so is finding difficulty in residing in a rented flat, and although she has expressed her desire to stay in the same house in the month of November 21, where your client so-and-so along with her daughter and son-in-law is residing now, which your client readily agreed to allow my client to stay with in the same house. But immediately after a few days, when my client approached your client, she flatly refused by stating that her daughter-in-law and son-in-law interfered in the matter and refused to allow my client to stay in the same house for reasons best known to them, and thereby forcefully and illegally deprive the genuine right of my client so-and-so to reside in the matrimonial home with her son so-and-so and so-and-so. Worth mentioning here that one of your client's grandchildren needs a homely environment for his mental and physical growth, which is not there in the rented flat where they are residing right now. How can your client be so cruel and inhuman to the family of her one and only deceased late Raktim Borgoya? Under the above facts and circumstances, it is hereby requested that my client should be given her share of the house as immediately as possible within the month of March 23, so that my client can stay peacefully and safely with her children. Now, this is again very important to establish her intent. Fourthly, as far as the share of my client so and so, my client's sister-in-law, Rimjim Borgoy, is concerned, my client has no objection in getting her 1/3 share of the Guwahati property. There is no explanation why. Fifthly, with regard to the remaining 2/3 property at Guwahati, my client wants half of the 2/3 of the remaining property right now, and the remaining half share of the 2/3 property of the mother-in-law, Srimati Nilima Borgoya, shall be devolved upon the two sons of my client, who are the grandsons of your client, which shall be enjoyed by the sons of my client, so and so and so and so, after the death of their grandmother, Srimati Nilima Borgoya, as they are the only living heir of late Raktim Borgoya and late Padmanath Borgoya. So she's taking a claim over the entire property in Guwahati, completely discounting the status of the daughter, and as far as the Shillong property is concerned, she raises an unjustified demand of 50% of the sale proceeds. So, what I'm trying to establish, my lords, by this particular letter, her intent. Her intent was not to derive her legitimate share, but her intent was to derive more than what was a legitimate share.
Anyway, this cannot be decided in a criminal.
I'm not. I'm only establishing her intent
confined to
as on
that.
23. As on March 23, this is her intent. Hello, just kindly take note of that. So following this, she realizes they don't give in to this demand. This is a completely unjustified demand. The petitioner does not give in to this. Kindly have page 51. They are met with a notice from the Assam Women's Commission. This is dated 20th of June 23. So there are two notices on both the pages, 51 and page 52. One is a notice dated 20th June 23 and the other 16th August 23. The petitioner and her daughter both appear before the Women's Commission. Nothing materializes except they orally remark that this is an entirely private dispute and should be taken up before the civil court. Thereafter, they receive yet another notice, which is at page 53. This is dated 20th of December 23 from the office of the Deputy Commissioner, East Khasi Hills. Now, this is addressed to the petitioner and her daughter, to the purchaser, who's at serial number 2, and to the complainant. It reads, objection petition, cancellation of mutation of plot number 44 situated at so-and-so, issued in favor of so-and-so and so-and-so. With reference to the subject cited above, I am to inform you to make it convenient to appear before the undersigned for hearing to be held on 22/1/24 at 12 noon in connection with the above mentioned objection petition by letter number so-and-so received from Mochumi K. Borgoya. The concerned parties are directed to bring all relevant documents in connection with the above mentioned matter. We appear on the 22nd through a counsel and we receive a copy of the objection petition, which is at page 54. Now, I'll just take your lordships through the contents of this very briefly. Kindly see the reference here. Prayer for cancellation of mutation of plot number 44, measuring so-and-so meters, more or less situated at Fruit Garden, Motinagar, Shillong, Meghalaya, issued in favor of Nilima Borgoya and Rimjim Borgoya, illegally in strict violation of the established procedure and arbitrary manner. Then she narrates the facts of her case and her entire claim. She makes references to the Hindu Succession Act and so on. And her prayer, my lords, is at page 58. Under the above facts and circumstances, my humble prayer before your honor to kindly cancel the mutation and issue a fresh mutation, including the names of the genuine legal heirs as immediately as possible, as well as declare the sale of plot number 44 as null and void, and for this act of yours, I shall remain ever grateful. Now, whether they have the jurisdiction, that's another thing, but the fact remains she has raised this issue before the necessary authorities. Now, thereafter, to our complete shock, we receive a notice under 41A, which is at page 59.
Yes.
This is a notice dated 18/1/24. This was sent to the Sadgaon police station in Guwahati. We received communication from them, we received it. So this is in connection, my lords will kindly find, addressed to Nilima Borgoya. And there are two additional notices, one issued to her daughter and the other to
Now
her
you
son.
reside in Guwahati. You do
They
not
reside in Guwahati. They've completely moved away. So this reads in exercise of the powers conferred under subsection 1 of 41 of CRPC. I hereby inform you that during the investigation of FIR by case number so and so under 417 IPC, registered at Laimukra police station, it is revealed that there are reasonable grounds to question you to ascertain facts and circumstances from you in relation to the present investigation. Hence, you are directed to appear before me within 7 days on receipt of this notice at Laimukra police station, and certain conditions are enumerated. So there are similar notices issued, which is at page 60. This is issued to the daughter, and at page 61 issued to the son-in-law, all in connection with the same FIR. So they engaged counsel here, and they initiated, they tried to procure certified copies of these documents as well as the FIR. Now the FIR is at page 62.
Yes.
So this is an FIR dated 28th of November 23. So kindly note, my lords, 21, 22, she already had knowledge of whatever her grievances was with regard to the illegal transfer and the illegal sale. As on March 23, she's again fully aware of the fact, and she raises an unjustified demand that you have to pay me 50% of the sale proceeds, as well as some certain other demands with regard to another property. When none of that works, she files a belated FIR on the 28th of November 23. Now again, her complaint is with regard to the mutation as well as the sale, and kindly see at page 66, she narrates everything. She again makes a reference to the Hindu Succession Act and so on to establish her right, and at page 66 is what she alleges. I am equally shocked, if lordships have it, page 66. I am equally shocked and surprised to see that the ADC revenue also granted the mutation certificate without obtaining the succession certificate, next of kin certificate or declaration on affidavit with respect to the legal heirs of the deceased, which is a very vital document while ascertaining the legal heirs of a deceased. Therefore, there is a serious breach in discharging the official duty by the concerned authority. Under the facts and circumstances on the basis of the prima facie evidence is produced before you, it is a humble request to kindly register a case under the proper section of law and initiate strictest action against the guilty without wasting any further time, any further loss of time. Now, upon receipt, what we've also obtained from the records, kindly have page 67. The IO conducts a preliminary inquiry in this matter, and he reports to the officer in charge by reporting that this is an inquiry report dated 16th December 23. What it reads is, with reference to the subject cited, I beg to report that I have personally inquired into the matter in connection with the above referred GD entry, and during inquiry it was learned that the case is non-cognizable in nature. It is therefore requested that non-cognizable report may kindly be forwarded to the Honourable Court as the case is non-cognizable offence, submitted for favour of your kind and necessary action. Following this, a letter dated 19th December 23 is issued by the OC to the concerned court at page 68. Forwarding of non-cognizable FIR dated so and so. May I just read this, my lord? With due respect and humble submission, I beg to inform that the Honourable Court on 20th November 23, a written complaint was received from Mochumi K. Borgoya, widow of so and so, resident of so and so, and the gist of the complaint is that her mother-in-law, namely so and so, Rimchim Borgoya and so and so, had illegally sold the property of late Padmanath Borgoya, bearing plot number 44, measuring so and so, which is situated Fruit Gardens, Motinagar, to so and so, without their knowledge, and illegally suppress the material fact about their existence as legal heirs of late Padmanath Borgoya. Further, the complainant learnt about the above illegal sale from her family friend in August 22, and she brought it to the notice of the ADC Revenue East Khasi Hills, Shillong, and applied for certified copy of the same. Also, she filed an RTI relating to the mutation and subsequent sale of the said property, and on receipt of the RTI reply, it revealed that they applied for a mutation certificate by fraudulent means and thus concealing the material facts about their existence as the legal heirs. Further, There is apprehension of claim and counterclaim over the property by both the parties, and the matter seems to be purely civil in nature and non-cognizable to police. Therefore, I'm forwarding herewith complaint with NCR form duly filled in your favor for favor of kind information of the Honorable Court and obliged. Now, pursuant to that, we also received a copy of an order which is at page 71.
Yes.
This is an order dated 13/1/24. This reads CR case record put up before me today as I'm duty magistrate. Seen the official FIR dated so and so filed at Limukra PS under 417 IPC. The informant is so and so. Accused persons as per FIR are so and so, so and so, and so and so. Seen also the court order dated 8/1/24 passed by the learned JMFC Srimati K. Rimbai via Limukra PS case number so and so dated 28/11/23 allowing the case to be registered under appropriate sections of law. Seen the case is endorsed to SI Mohammed Qayyum for investigation, IO to take steps to expedite the investigation at the earliest. So what Lordships will notice is upon receipt of the FIR, the first call that they took was that this was a non-cognizable offence, and number two, that this was purely civil in nature, and forwarded it to the court. The court then directed them to register the case and take steps for investigation. Now, the three planks on which I'm basing my case: number one, 415 in the facts of this case is not attracted at all because there was no cause of inducement or misrepresentation. Because she claims in her FIR as well as all her complaints that everything was done behind her back. Everything was done behind her back. So clearly there was no occasion for any kind of misrepresentation or inducement. At all, if anybody had any locus, were the purchasers. They could have filed an FIR under 415, claiming to have been cheated.
What happened to our objection before the Revenue Authority?
A date has been fixed for filing of show cause by all the parties because the notice was also sent to the
Nothing has
purchaser.
been done. The sale also stands.
Lordship, sale also stands.
Those who are not challenged.
Not challenged. If your Lordships will see from that last letter to the ADC, she's asking the ADC to declare the sale as void. She has not appraised the civil court as yet. She has been aware of this since 22, but till 24, there is no civil suit to the best of our knowledge. The FIR is also a belated FIR in the month of November 23. Now, three issues. Number one, that 415 is not attracted. Lordships will kindly examine that. The other two most important issues, in my humble submission, this is a purely civil case. There is no criminal element involved at all. There's one thing that they say that I have suppressed certain documents. I have suppressed the fact that she is a legal heir. Lordships will also find from her claims that she claims that the entire property had been verbally given to her deceased husband. Now that is another matter which has to be established before a civil court. So these are factors which have to be decided only by a civil court, not by any other authority. So the very fact that this entire dispute reeks of a civil dispute could not have been converted into a criminal case. Now, from the facts, Lordship will notice just two things. She was aware of this as far back as 22. She did not take any steps. She, in the month of March 23, by way of a legal notice, she presented a demand. The demand, and I can take Lordships through the Hindu Succession Act to indicate that her demand was completely unjustified. Legally, as per the natural course of devolution, she would not be entitled to that share.
Not decide those aspects of the matter, the rightful claim and all. We are just trying to find out whether any criminality is. So
Fair enough.
That is
so why I'm
not
saying,
go beyond that thing. Who has
why
a
I'm
better
saying-
title, who would have a rightful
I
claim?
understand.
This court will not decide.
So Lordships will
Act
see.
remains that all along her demand was that please disburse me my share. It appears that there is a dispute with regard to the share. She wants
share.
more.
She
will
wants
say
much more.
So that is what the thing.
So all I'm saying, Lordships will find from the records, number one, that we have never shied away from giving her share. She records it in her own reply. She says, we are going to give you your share. But she says, I don't want that share. I want half share of the sale proceeds. We are saying that's an unjustified demand. Now, because we do not give in to her share, as late as November 23, she decides to initiate criminal proceedings. Now, when talks of settlement are underway, in order to influence the entire settlement and to derive some sort of an outcome, desired outcome, one cannot file an FIR. This is completely malified. So in support of that, I could place just a few decisions.
It's not required right now, Mr. Let us see what the other side says.
Lordship.
Yes.
Please, Lordship. Lordship, the respondent number 4, Lordship, has filed an objection for cancellation of the mutation in the office of the Deputy Commissioner. The Deputy Commissioner has issued the notice to the petitioners to appear, and they have appeared, Lordship, and they have asked for copies of the documents. So now this objection is pending before the Deputy
That is all
Commissioner,
right. So what
Revenue.
is this? You see, like the process before the other authorities. This
Yes.
court is not at all concerned right now. Only that is what is that the FIR.
And as it appears from this petition, Lordship, the son of the petitioner, he has relinquished his share during his lifetime. And also after he died, the daughter-in-law also, she informed them that she is not claiming any share
So
for
you are
herself and
supporting
for
his
her
case.
children.
You are
And but
supporting his
after
case.
that, but after the sale, Lordship, she filed the FIR and the objection. But there is no documentary proof to show that she has relinquished her claim. This is, and the investigation is going on, under investigation. The case has
That's
been
all right.
raised.
The thing is that after she found out that the mutation was done and the property was sold off,
So,
thereafter also she did not file any FIR.
yes.
She basically asked for her claim.
She asked for a claim.
And it
And they
transpired
have-
that
they
there is
have-
a dispute with regard to the claim of
The
share.
claim. They have
So
agreed
how
to
much?
give her 1/3.
So that suddenly
But
she
she's
files
claiming
an FIR.
50%.
Will issue, not issue.
Lordship, I'm only praying for some sort of relief, my lords. I'm praying for stay of the inquiry.
Hard.
The IO will be very happy if the parties settle.
What for this
This is-
miscases?
For stay of the proceedings, my lord.
This is required.
Lords, otherwise, the 41 notice is still alive.
But that is all right.
They have
But then
not-
separate application is needed, not needed.
Look,
There
I
is
have discussed with the IO, Lordship, and he said he's very happy if the parties settle among themselves. This is purely a civil matter, property
Where
dispute.
is a miscellaneous application?
But since they have filed the FIR, so they have to
Any for
register a
interim
case.
miscellaneous application is needed. I don't think it is needed.
That is the practice that we follow, my lords.
Is it?
If I recall correctly, there was a
It
standing
was
order
there
from.
before, but then now I don't think it is there anymore. Anyway, verify.
I'll verify that. Well, it's in criminal petition 9. My miscase is 18. Miscase 18. And the prayer is at page 12.
Yes, okay. Just in the main petition, just say, Mr. Question. Land Council appealing for the petitioner. Issue notice returable in 3 weeks. Mr. H. Karni. Landed additional senior GA. Yes, for
1, 2, and
1 and 1 and 2.
1, 3,
1, 2 and 3, yes.
1, 2, and 3. And as such, no formal notice, no formal notice is called for in respect of the said respondents. However, the petitioner shall take steps for service of notice upon the respondent number 4
4.
within 2 days.
2 days.
Okay. Well, is it required that he pass separate order in the miscase?
Lordships could pass in the main order itself. There's no difficulty.
Well, just say we will not pass any detailed order. We will just give a paragraph at the interim. It is provided that the further proceeding in connection with what case number is this one?
FIR dated so and so. Case numbers 7.
Yes, it should be
Lime crab.
Lime
It should be lime crab PS case.
Your prayer has that did not say this is only case number is given.
It should be lime crab PS case, Lordship.
See, come to page 19.
I apologize. It should be Limecra PS.
Lime crab PS case.
I
Lime
apologize.
crab PS case number 7 in bracket 1 2024.
If I did it so in case number so now here you have mentioned that like crap is case number. Yes, even in the cost title also it is like that.
Yes. Cost title also.
Page 2 on the top, just see it is like that.
Lordship.
Page 1 also.
Page 1 also it is.
Page
like
1 also.
that. In the entrance,
Oh, this one is
in the
bestowed.
interim, it is. With connection with Lithomograph PS case number. Do not say FIR. PS case number 07 within bracket 01 2024 under section 470 IPC. Registered on the basis of FIR dated 28/11/2023. Shall remain stayed till the returnable date.
Lordship. Highly obliged. But
Well,
similar order
2
for
two
the
and
other
3
two.
are similar matter filed by the daughter and
By the other family
son-in-law.
members.
Same situation.
Same.
Same FIR,
Same
41
FIR.
members.
Same.
Okay, so 2-3 also, item number 2-3 also same order of law. And in this case, we just say, in view of the order passed, in the petition number so and so, in all those cases menu, okay? No order is called for.
Yes. No,
No separate order is
No
called.
separate
Let me
order.
case.
Same.
Lordship.
And we will just see if not required in the next day we can dispose of the miscases.
Lordship.
Yes.
Highly obliged.
Obliged, Lordship.
May I list item number 1?
Yes.
May it please, Your Lordship. Lordship, we are still awaiting instructions pertaining to filing of an affidavit, Your Lordship.
Is it 2022 matter?
Lordship, yes.
How long will we wait for instructions?
Your Lordship, we are finding a little difficulty in contacting the concerned respondents. Your
Why?
Lordship.
The department has disappeared. It's a million, isn't it?
Your Lordship, the respondents, 2 of the respondents, they are from out stations.
Yes, Mr.
Yes,
Abadai.
Lordship. They are from outside
Yes.
state,
Miss
Chhattisgarh and
Miss so appearing on behalf of the respondents. Wait for praise for grant of some more time for enabling the respondent number 9, 10, 11 to file their counter affidavit in the matter. Prayer allowed. List after 3 weeks.
3 weeks, Your Lordship.
Lordship.
Much obliged, Your Lordship.
Item number 2?
My lord, I'm yet to receive the certificate, my lord. I'm praying for 1 week time for the certificate.
May be granted, Lordship.
Arjata, London Legal Aid Council, please for grant of further 1 week's time for filing an affidavit in support of the service of notice of the respondent number
Yes,
3.
my lord.
Prayer allowed. List after week.
Obliged.
Item number 3?
My lord, the state respondents have filed the affidavit
Yes.
and they have enclosed the postmortem report also, my lord. My lord, I have gone through the postmortem report, my lord. I am shocked, my lord, how this postmortem has been conducted. Number 1, my lord. Number 2, the postmortem is it's not a postmortem report, my lord. It's a inquest report. No dissection of the body was done, my lord. The doctor came to a finding that the cause of death is asphyxia due to drowning. Now, how this has been arrived at is not known. The other aspect of the matter is that this person, the body was found with injuries. One injury on the temple.
That is the basis for which you filed a second FIR. You see.
My lord. Now, my lord, at this stage, I will only say, since I have not, my simple prayer in this 482 petition was that investigation has to be conducted in accordance with law. Now, my lord, investigation is proceeding as I can see from here. So, my lord, this matter may be closed, giving me the liberty to file an appropriate.
That will remain with you.
My lord.
Or you can approach also 1563 of the CRPC before the jurisdictional magistrate.
Yes.
Remedy is there.
That is also there. In case.
The postmortem was completed within 20 minutes.
Anyway, these are all things which cannot be decided here.
Not in terms of my prayer. In terms of their affidavit, it also appears that they had filed a UD case and filed an FR. Then only after we filed the FIR.
They have reopened the thing.
Yes.
And now the investigation is going.
Yes, sir.
That is hard. London Council. Just named. Okay. This application under Prohibited to CRPC was filed. Here. To direct the state respondents to conduct proper investigation, reinvestigation in William Nagar PS case number
24/5.
24 within bracket 05 2023. The state respondents upon issuance of notice in the matter, the state respondent has now filed a short affidavit bringing into record the progress of the investigation
Lordship.
in the matter. Stop. The perusal of the said affidavit reveals that the investigation is undergoing and the statement of view statement of some persons, including that of the complainant and the victim's mothers, have been recorded. It appears that mobile phone of the alleged accused have also been sent for FSR examination. When it is likely to be completed, Mr. Sulai?
Lordship, because the investigation is going on now. Mobile phone also has been sent for FSL, Lordship.
Yes,
As and when the investigation is then we'll do the needful, Lordship.
Mr. Andy Sulai, learned AG submit that the investigation is going in full progress, but the same is likely to be completed at the earliest. Yes, sir. In view, next paragraph, in view of the submission made, there remains nothing to be decided in this criminal petition. And the same is closed as infructuous. However, it is made clear that the petitioner will have the liberty to come up with his grievance. No, to raise. Oh no, just say the petitioner will have the liberty to approach the appropriate authority under law in case there remains or there appears to be some grievance still remains to be redressed. The order, opposite order, the petition stand disposal of.
Apply, Lord.
Item number 4.
Yes, some correction in that.
4.
Yes.
Please, Lordship. This matter we have filed the affidavit of service where the respondent number 4, 5, and 6 has received. The annexed 1 we have put it in the affidavit of service. The postmaster has written in this matter.
Case about?
This is a case about whereby the police has registered the FIR against the petitioner for non-cognizable offence.
That's right, non-cognizable.
Yes.
So if this thing notice has been served on the other
Yes,
side?
yes. It is the page.
Yes.
It is there in the annexure 1. This is a senior superintendent. He has issued a letter stating that.
I'll have instruction. What is the stage of investigation now?
Non-cognizable offence, what instruction you need? That
Lordship,
is what you say that the state will go by that. It is not that you have to take
Lordship,
that.
can you see the FIR, your Lordship?
Yes.
Lordship, can you see that allegation that there was illegal mining and all that is
Section 155(2) of CRPC stated that in cognizable and incognizable offence, the police has to
Have you
report
raised
to
those
the
points in your
magistrate.
petition? Is there a mention of those points in your petition?
I will at the time of hearing I will satisfy Lordship.
there is a false allegation against the district administration and all?
All those things will come. There is a judgment also. The state of Haryana.
Lordship will have instruction. What is
let
Maybe
the private respondent file the
something is
affidavit.
Private respondent has not entered appearance, isn't it?
Yes, let them file the affidavit.
If they do not appear, how they will file the affidavit?
That's
right. An affidavit in support. Yes, a hard learning counsel of the parties. Then you say an affidavit in support of service of notice. Affidavit in support of service of notice. On respondent number. Who are the respondents?
4 and
5 and 6.
4, 5 and 6. 4, 5 and 6
has been filed by the petitioner by enclosing. What is the postal report? Why do you use a postal report?
Postal report. This.
There is no postal receipt here.
No, annex affidavit of service.
That is affidavit. That is service. There is not a postal receipt. Is it a postal receipt?
No, this is the letter from the senior superintendent of post
petition. What you have said in paragraph 2, page 2, photocopy of the postal receipt. Is it a postal receipt?
Actually, it is not a postal receipt, but this is the actually supposed to be the letter. By the way, I think my colleague. This is the letter from the senior superintendent of police supposed to be.
What did he say? Don't say wherein a letter issued by a letter dated 16th February 2024 issued by the Meghalaya Postal Division has been appended as per the said letter, notices upon the said respondents are duly served. Give a stop. However, when the matter was called out today, none appeared for the said respondent number 4, 5, and 6. So, Mr. Shula, you will have instruction.
Lordship, yes, let me
Give a paragraph. Say, Mr. Andy Shula, learned additional HE. Please for grant some time in order to enable him to obtain necessary instruction on the matter. Prayer allowed list
after 2 weeks,
after 2 weeks.
Apply.
What's the Lordship?
Hearing item number 6.
Yes, Mr. Mohan.
Yes. Lordship, conducting counsel is on legs before the division bench. So this matter may come at the bottom of the list or after 1 week, Lordship, which is
Lordship, please.
What is this, Mr. Mohan?
This matter for framing of charges against that I have come. Initially, it was framed by the
Challenging the order of framing.
Yeah, framing of charges.
In what case? What matter?
This is video 354, and the petitioner is also female, and the nurse, she is also female. She give the allegation that about 354.
Outraging the modesty.
Modesty. That's a case. Means only the gender neutral.
I think by that time there will be.
Lordship, I have not received instructions. So I have not received instructions on that.
No instruction is needed. This is a challenge to the order. What instruction is needed?
Lordship, I'm praying for time.
So this is only hampering with the gender neutral, that clause. Section 8 of the IPC. The gender neutral, they hold the gender neutral. He who molests the woman. So he suffice to the male. That was my contention.
So, Lordship, on
He
the
would mean a male. A female would not come.
No,
so 354 will not be attracted.
No,
if this kind of incident takes between two females.
But however, Mumbai High Court said that if a female molests another female in a public places, then definitely it will be attracted. Mumbai High Court one decision is there.
Interesting.
So, and in the Supreme Court, they say the LGBT those cases, these are the personal laws. So it's the parliament to, it's a fit case for the parliament to decide this, not by the court to
So
decide.
as of now, there is no law which says that charge cannot be framed.
Yes.
Under 354 in case.
Lordship, on
Then
the
what remains
definition
to be
of
decided in your
IPC.
case? Then what remains in your case then? If you say so,
that
then prima facie there is no illegality in framing of the order of framing of charges.
No, I want to advance that argument, Your Lordship. Therefore. Well, he expressed difficulties slightly after 1
No,
week.
that is all right. That is all right.
On the definition of IPC, Lordship, it has been stated that the he that is stated in this section is gender applies to he and she as well, Lordship. So,
on what basis you say?
Lordship, in the definition.
No, you say if you say it applies to he and she. On
Yes.
what basis? What is the basis of your saying?
The basis is that, Lordship, in that section which says that whoever he molests, that definition he has been defined in the IPC, and that he includes she as well.
I know that.
Yes, a prayer has been made on behalf of Mr. Ravi Guru.
Yes, Lordship.
Our Guru. On the ground that a prayer has just say a mention has been made on behalf of the to adjourn the matter for a week. The Honorable Senior Counsel appearing for the petitioner has no objection. Prayer allowed. List after week.
Obliged.
Item number 8.
May please, Lordship.
Yes.
Lordship, the conducting counsel is on legs, Your Lordship.
You will conduct.
Okay, the matter may be taken up.
You conduct. You start it. We'll just see petition is there. You are holding the brief. Open the thing. We'll just see what is there.
Your Lordship, the conducting counsel is handling with this matter, Your Lordship.
You are also conducting counsel, isn't it? What is the case about? Just tell
Your
us.
Lordship, this is a 482
Take
matter.
this chance. Why not? At least open the case. Let us see. If you have difficulty, we'll adjourn it.
Your Lordship, this is a 482 matters, Your Lordship, for questioning of criminal proceedings and a complaint passed by a designate magistrate. Then the trial court, Your Lordship. Your Lordship, in this matter, the petitioner is alleged that he was in charge of manufacturing the drugs, which is not of the standard quality, Your Lordship.
Substandard quality.
Not of standard quality, Your Lordship.
And what ground you are challenging it?
Your Lordship, there are many grounds on which we are challenging this petition. Your Lordship. However, one of such grounds is that, Your Lordship, merely because I was the managing director, Your Lordship, merely because I was a director of a company is not sufficient, Your Lordship, to establish the offence was committed with my consent or connivance, Your Lordship, in this case. Also, Your Lordship, the directors, merely because they are being the directors of the company, Your Lordship, they are not responsible, Your Lordship, for the day-to-day activities, Your Lordship.
Then who will be responsible? In the event if anything goes wrong, then who will take the responsibility? One.
The directors, Your Lordship, however, Your Lordship, here, Your Lordship, here, merely because they are the director of the company, Your Lordship, it is not sufficient, Your Lordship, to establish that the offence was committed by their consent, Your Lordship. Your Lordship, I pray that the matter may be taken up on the other day, Your Lordship. The conducting counsel is on legs.
You said it at the beginning. Why you are saying it again? Court is not inclined to accept your request. So you have no other option but to proceed.
Your Lordship, I pray for the same, Your Lordship, as the...
That prayer also will reject. Where is the complaint?
Page 31, Your Lordship, an extra 2.
Okay. It comes as a CR case. It is filed as a
Yes, Your Lordship.
complaint before the court.
Yes, Your Lordship.
Under the Drugs and Cosmetics Act.
Yes, Your Lordship.
And what is the punishment here? Maximum punishment?
Your Lordship, the penalty for manufacture or spurious or adulterated drugs has been enhanced in imprisonment for a term which shall not be less than 10 years, but which may extend to imprisonment for life and shall
This
also...
punishment under 27D.
Yes, Your Lordship.
Just see punishable. This punishment under 27D and 28A.
That's the proximate.
Yes. What's the punishment? And we just say, when do you want it?
Your Lordship, after 2 weeks, Your Lordship.
Just say here on the joint request made by the parties, list this matter for 2 weeks. Any interim order in this matter? No. No interim order. You are supposed to file an affidavit in this matter. Have you filed it? If the first order says that you will file an affidavit, and then Acha, has been filed.
Already filed, Your Lordship, 20th September 2000.
It is filed, you do not know.
Your Lordship, I thought additional affidavit or